welcome everyone to another episode today of the Empowered Immigrant Live. Thank you so much for being here. Today I want to discuss the case of Mr. Abrego Garcia and why it matters and what you need to know about it. And so thank you for tuning in here today. It's the 26th of August of 2025 is when I'm recording this. And I appreciate everybody tuning in here on a beautiful Tuesday morning to discuss immigration law here on our episode of the Empowered Immigrant Live. Remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. And today our theme is the case of Mr. Abrego Garcia, and why that matters and what you need to know about it. And so thank you so much for tuning in right now. Really appreciate your being here, whether you're on YouTube, Facebook, LinkedIn, Instagram, or TikTok. And welcome and thank you so much. All right. My question, as always, is do you want to get a green card? Do you want to apply for asylum? Do you want to apply for a U visa or VAWA? You want to defend yourself from deportation? Whatever it is, do you want help figuring out what is the best strategy? What is the best way? What is the best option for you to up-level your life through immigration laws? Because if you're in that situation, go for it, and I'd love to help you with it. Okay, my firm is on a mission to win 10,000 immigration cases in the next 10 years, and we would love for your case to be one of them. All right? So thanks to everyone for being here. Really appreciate all of you. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. I'm also a certified specialist in immigration nationality law, and I'm the host of the Empowered Immigrant Live. So thank you so much for being here, and welcome. As I'm talking, if you have questions, feel free to submit your questions, and I will do my best to answer them. All right. So the case of Kilmar Abrego Garcia. All right. This is what has happened in his case. All right. Kilmar Abrego Garcia is originally from El Salvador. Okay. He escaped gang threats and violence in his youth, and he entered the U.S. without inspection in 2011. At that time, he was 16 years old. Okay, he fought asylum and he lost. But instead of asylum, he won what we call withholding of removal. And he won withholding in 2019. And remember that when a judge grants withholding of removal, I've done episodes, feel free to see in our YouTube or on our website if you want more information about what withholding of removal means. But when a judge grants withholding of removal, the order is actually a deportation order. They say, we are ordering you deported, but your deportation is subject to a grant of withholding of removal. All right? And so it's basically saying, hey, the judge is ordering that you cannot be removed, you cannot be deported to your home country, right? Because of violence or death threats or things of that nature, or if you're going to be tortured or killed in your home country, you can't be eligible to be deported to that country. So then that all happened in 2019, right? Mr. Kilmar Abrego Garcia was just fine under the Biden administration and even under the prior Trump administration. But then in March of 2025, so March of this year, Trump detains him and deports him to El Salvador, quote unquote, in error. Whoops, sorry, we deported you in direct violation of that withholding of removal order. Because remember, the judge had ordered his deportation, but had granted withholding of removal from El Salvador. Right? So Trump deported him to the very country that it was illegal for them to deport him there. Okay? Which is why in April of 2025, a federal judge ordered the Trump administration to bring him back. Right? You can't deport somebody in violation of a judge's order to that country. And so in June of 2025, took several months, he was returned. But he was detained and he was charged with certain criminal acts. He was charged with pretty serious crimes, actually, in the state of Tennessee. All right? And crimes involving the human smuggling of immigrants inside the United States, out of the state of Texas to other states within the United States. All right, pretty serious charges. All right, and so that all has happened. And then what has happened just in the last couple days? So they're fighting criminal allegations and charges. All right, and he was released finally from custody last Friday, and he was reunited with his family. All right, I believe his family all lives in Maryland. And so he was released and he was reunited with his family, but he had an ICE check-in yesterday morning. So he had the weekend, and yesterday morning ICE re-detained him. And now they are saying that they're going to deport him not to El Salvador, but instead they're threatening that they're going to deport him to Uganda. Okay? Which he has nothing to do with Uganda. And so that's where we're at. And that's what's happening. And you got to be aware that that's happening. Right? Isn't that crazy? It's a crazy story. Right? He's still facing criminal charges in Tennessee, but now they're going to deport him to Uganda. But it's like, wait a second, is he guilty of what has happened in Tennessee or isn't he? Like, is there actually a finding of guilt? No, not yet. He's in that process. It's that case, that process has just begun. Right? You would think that someone would be presumed innocent until proven guilty beyond a reasonable doubt, as is required by the United States Constitution. All right? You would hope that somebody has the right to due process and the right to actually defend themselves from criminal prosecution. And this individual has had lawful immigration status since 2019. And now we're just throwing it away and sending him to Uganda without without addressing that removal order that was subject to a grant of withholding of removal. Like, is that even legal? Is it legal to deport somebody who's been granted withholding of removal to a third country? Right? Is it? That's an interesting question. You know, the Supreme Court's divided on this question, folks. Like, Sotomayor says, no, that's not legal at all. You know, that's not legal. Read her dissent. Right? In the matter of DVD versus DHS. But that was a dissent. The majority opinion allowed it to happen. And so far, yes, they're doing it. Right? According to the International Refugee Assistance Project, so far they've deported 350 immigrants to Panama, 200 to Costa Rica, about 13 or so to different countries in Africa that are in this situation. Like, it is happening. It's not a huge volume of people, but they are doing it. They are doing it. Right? And so why does this case matter to you? Why does this case matter? Well, I've got lots of clients who have won withholding of removal. I've won withholding of removal for people over the years. And relief under CAT, relief under the Convention Against Torture. We call it CAT. All right? People who are in that situation, it's like if this happens, people who are in that situation, in theory, could face deportation to a third country. And so if you're in that situation, you've got to be aware. And I have clients who, I'm glad you're being proactive and reaching out and like, hey, let's get your records and let's work on it and let's get to the bottom of it and let's create a game plan. That's the right approach, right? If you're in that situation, you do not want to just do nothing. You do not want to just, oh, I'm going to wait around and see what happens. No, all right? Meet with your lawyer. Get your records. Develop a strategy so that we can defend you or reopen your case or submit some other application if we could do that. You want to be proactive. Okay? You want to be proactive. You want to be clear about what risks you really are facing. The best advice in this is first get an assessment of the risks that you are actually facing. All right? Some people, the risks are very high. Other people, the risks are not so high. All right? Based on what we're really seeing. But you want to understand them. You want to get clarity about them. And then you want to understand your options. Might you be eligible for something else? Might you be eligible to reopen that case? You want to get good advice. You want to get good counsel. Okay? So that's all that I've got about that case. And so I see some questions coming in, so keep sending me your questions, and I'll do my best. And if you're just tuning in right now, hey, welcome to today's episode of the Empowered Immigrant Live. Thank you so much for being here. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And so thank you. So my first question here today, let's see, it comes from, Gilberto Diaz. I see your question here. You say, espero que se encuentre bien. Mi esposa acaba de recibir su residencia. Oh, man. Felicidades. All right. My wife just won her residence. Can she fix papers for me? ¿Me puede arreglar? Pregunta excelente. All right, Mr. Diaz. Thank you so much for asking it. Pregunta excelente. So remember, right, a resident, a green card holding spouse, can file an I-130 petition for a spouse. That petition says two things. It says first, your wife is a lawful permanent resident of the United States. They got to have a green card. And second, it says that you and her are in a lawful and good faith marriage. That's what the I-130 says. All right, that I-130 is approvable. All right. The second question, though, and maybe this is where you need to start, is can you use that petition? And that depends on several things. When have you arrived to the United States? How did you arrive to the United States? And have you ever triggered any of what they call inadmissibility? All right. And so, have you ever been arrested? Have you ever used, possessed, cultivated, sold, had anything to do with any illegal drug, narcotic, including marijuana? Have you ever made a false claim to U.S. citizenship? Have you ever misrepresented anything to immigration before? Have you ever helped any other immigrant enter the U.S. without permission? And lots of other questions, all right? And so we've got to get to the bottom of all of that, Mr. Diaz, in order to assess whether or not your wife can fix your status, right? Have you ever been deported in the past, right? All of these questions we've got to get to the bottom of, and we do that in a consultation, and we'd love to do a consultation with you, and we'd love to help you through it. I hope that's helpful for you. I know you asked your question in Spanish. I will be doing this episode in Spanish in just a few moments. All right, so if you want to join us and hear that in detail in Spanish, que venga y podemos hacerlo en español en unos minutos. All right? So let's see. My next question here is from Clavicular 838374. Great to see you here. Thank you so much for asking this. You say, what are my chances of getting PD or a motion to terminate after receiving the U visa bona fide determination if there's good moral character? In my experience, the chances are low. All right, the chances are low because a U visa bona fide determination does not grant you immigration status, right? Perhaps it depends on which court you're in. Perhaps it depends on the judge that you have. You could certainly try a motion to terminate. It used to be very common under Biden, under the Biden administration to get prosecutorial discretion, PD, or a motion to dismiss or terminate once you had a U visa bona fide determination when you can show there's good moral character. But right now, I don't think that that's happening, right? But if there's something else you could do, or something else you could fight, then do that. And and if you're looking for legal help on how to navigate that, then feel free to reach out. Right, we're here to help. We'd love to help. All right, Sandal Scandal. You say, who cares? Just get rid of them all. Yeah, you're on the wrong channel, man. You're on the wrong channel. I love immigrants. Immigrants are some of the strongest people on planet Earth. And I think we should be welcoming them, not getting rid of them, as you say. Right? So I respectfully disagree. Blue Sky, you say, I applied for a green card in October of last year and I haven't heard anything. How soon will I receive word? You applied for a green card in October. Okay. So the question becomes what type of green card, right? Was it a U.S. citizen spouse that petitioned for you? Was it a green card holding spouse that petitioned for you? Was it a child who petitioned for you? Was it through the diversity green card lottery that you applied through? Are you currently inside the U.S.? Are you outside the U.S.? Was it through a U visa? Was it through asylum? All of these things have different processing times, all right? And some of these cases are done in 8 months, and some of these cases take 15 years or more, right? 30 years potentially, right? Depending on where you're from. And so, feel free to schedule a consult and we can really look at it if you want to do that. But without knowing more, it's going to be impossible for me to really precisely answer your question. All right, Chief Hart, I see your question here. You say, does USCIS retain PD for VAWA under LPR spouses if the abuser filed an I-130 that is pending for years ago? This is a complicated question. So you're saying the green card holding spouse, abusive green card holding spouse, filed an I-130, and now you're filing for VAWA, right? And you're wondering, do they retain the priority date for VAWA under the I-130, or is it the I-360's priority date that governs? That's a complicated question. I don't want to say one way or the other here live and then be wrong, but I'd be happy to look it up for you. All right, I'd be happy to look it up for you, but that's not something that I could just Google real quick, right? I'd have to look up the regulations and make sure that it's accurate. I'd be happy to do that, but we would need to actually do a consult to figure that out. I hope that you, well, first of all, I'm sorry that you're in the situation where you've had a green card holding spouse who has been abusive, right? And I'm glad that you are moving forward with VAWA, right? And so yeah, whether or not you retain your new priority date or your I-130's priority date, it's almost like if you're eligible for VAWA, file for VAWA even if. It almost doesn't matter which priority date they're taking. I mean, of course it's good to know, but it's like if you're filing for VAWA, do that if that's the situation. Talk to a lawyer first, have representation, but and I'd be happy to research that nuance for you if you're actually working with my team in any way in it. But anyway, I hope that's helpful, and thank you for asking your question. All right, Arturo Saucedo, ¿qué es una audiencia preliminar? All right, so let me thank you for this. In English, your question is, what is a preliminary hearing, or what is a quote-unquote master calendar hearing? And this is a great question. Thank you for asking it. The way it works in immigration court is when a person is first put into immigration court proceedings, they are scheduled for what's called a master calendar hearing, all right? Or in Spanish, una audiencia preliminar, all right? And so in that master calendar hearing, imagine that there's 50 people in a courtroom, and imagine each one has 5 minutes, and they go up with their attorney one at a time, and the judge will call your case, and then we go up and we say, hey, Your Honor, nice to meet you, good morning, how you doing, right? And yes, we've received the notice to appear, and here's how we're going to respond to the allegations, and here's how we're going to respond to the charges, and don't deport my client, Judge. Why? Because they're applying for cancellation of removal, or asylum, or VAWA, or whatever it is we're applying for, all right? And then the judge says, okay, counsel, nice to meet you, nice to see you. By when will you submit the paperwork? And then we say, okay, Your Honor, give us 60 days, right? Give us 90 days, whatever the situation is, right? How much time you need? And then the judge will say, or the government attorney might say, objection, that's way too much time for that type of case, or they might say, yeah, that's fine, and they'll reset it or give you a scheduling order to get your application on file, and then eventually set your case to what's called a individual hearing, which is the trial. At the individual hearing, right, they will ask and take testimony, and you'll be sworn under oath to tell the truth, the whole truth, nothing but the truth, and they will, your attorney will ask you questions about why are you afraid for your life to return to your home country, or about whatever type of application you've submitted, right? And then a judge will make a decision. That's the process. So the preliminary hearing is just the first step of a very long process in immigration court, and that's the way it works. Okay, let's see. A-Walls 7175, you say, is there going to be a way to check if one's visa is still valid after the announced review? Not to my knowledge. Not to my knowledge. After the announced review, I don't know. I don't even know what precisely you're referring to. A-Walls, thank you for asking this. I don't know precisely what you're referring to. The way to check if one visa is valid, it depends on what type of visa it is. All right, is it a student visa? Is it a tourist visa? Is it a U visa? There's different ways to check validity in different places, but yeah, get legal advice if you're not clear whether or not your visa is still valid. All right. Okay, Chief Hart, you say, can someone adjust through an F2A if the initial entry was iwi, but you later traveled with advanced parole and you have a legal entry now? No, you can't. All right, F2A is on the preference category system as the spouse of a green card holder. And so because of that, no, you have to be in valid immigration status in order to adjust status through F2A. So often what we do there is, hey, have your spouse become a citizen. Because if your spouse becomes a citizen, now you can adjust as a quote-unquote immediate relative. Why? Because you have the advanced parole entry. You have the legal entry. All right? I hope that's clear. And that you still have to be admissible. You still have to meet the other requirements, but at least you don't have to. One of the requirements when you're adjusting through an immediate relative, like a U.S. citizen spouse, is not that you're currently in valid legal status. Okay, should I say that again? It is not a requirement to be in valid legal status to adjust status through a U.S. spouse. In other words, it's only a requirement that you were inspected and admitted or paroled into the United States, and that you're in a bona fide relationship with that spouse, and that you're quote-unquote admissible. We clear? Immigration law, right? I didn't write it. It was Congress that wrote it. I'm just explaining it, all right, as best as I can. But yeah, it is convoluted. That is the way it works, though. All right, feel free to reach out if you have questions about that. All right, you want to be clear that you are eligible. But no, if you are not in current legal status, then you cannot adjust status through the preference categories through the visa bulletin, including through category F2A. All right, hope that's helpful. So El Polcas, you say U visa, May of 2017. Should I get an A919 EAD work permit in October? That's a good question. They're coming up, all right? Our 2017 U visas some have been approved, some are still pending, right? So, and yes, October is the beginning of the new fiscal year. And so it's very possible that you could, but it's impossible for me to accurately predict, right, whether or not you should expect one in October without fully reviewing your case. And even then, just knowing the priority dates, I'm not in a place to just like say yes or no. But hopefully you do, all right? Let's see, Itserik 102. I filed for a Form G325A for deferred action. How long does it take to get an answer? Yeah, if this is military deferred action, they take a ridiculously long amount of time. We've had multiple cases that just kind of go into a black hole and they seem to have gone nowhere. At least 2 years is what I'm experiencing, right? It depends on your field office, but yes, they're slow and ridiculous and frustrating is the honest truth about those. All right, Maria Lacerda. Can people with U visa processes apply for citizenship after completing the process someday? Yeah, thank you for asking that. The way it works is win the U visa first, all right? After you have a U visa, you have to wait 3 years to apply for a green card. After you win a green card, then you've got to wait 5 years and you can apply for citizenship. And that's the way it works. And there's a bunch of other requirements, all right? You've got to show you're a person of good moral character. You've got to show that you've been maintaining your green card, that you haven't had long exits outside of the U.S. that would have caused you to abandon your green card, or that would have caused a disruption in your continuous physical presence in the U.S. There's lots of requirements. Go through them with a lawyer before making the decision to apply for citizenship, but that is the way it works. First, you win the visa, then you wait 3 years, you can apply for a green card, then you wait and maintain good moral character, pay your taxes, obey all laws, etc. for 5 years, and you can apply for U.S. citizenship. All right, it's not automatic. Each of these steps have a process to go through, all right, and require interviews with government officers, etc. All right, Michael, you say, hello, sir. Any news about Syria TPS? How many years should I be in good moral character for non-LPR cancellation of removal? All right, I don't have any big news right here to share about Syria TPS, but for good moral character, you've got to show 10 years of good moral character for non-LPR cancellation of removal, E42B, okay? And so 10 years of physical presence and 10 years of good moral character. And you really want to be, really want to document that well, all right? E42B, non-LPR cancellation of removal cases are difficult, all right? They are not automatic. I hope you have a lawyer who is helping you through that process. All right, very good. De todo un poco, you say, tengo DACA. All right, awesome. Y estoy casado con ciudadana, pero no tengo entrada legal. ¿Qué recomienda? Advance parole. All right, so I have DACA, and I'm married to a U.S. citizen, but I don't have a legal entry into the country. What do you recommend? Advance parole. Yes, so remember, advance parole. So when you have DACA, you're eligible to apply for a travel document, and there's three options or three legal bases for requesting a travel document through DACA. What are the three? Anybody know? All right. First is what we call a humanitarian purpose. You got to show that there's some humanitarian purpose for your trip. The second is an education-based purpose. So if you're going to study abroad, or if there's like a conference or something that you need for your employment in another country, you could travel. And the third is an employment-based opportunity in your home, in a country, in the country you're traveling to. Any of those three things give you the ability through DACA to request a travel document. Once you have the travel document, you leave, then you re-enter. When you're re-entering the U.S., you're paroled into the U.S. through DACA. All right? After being paroled into the U.S., now you could adjust status through a U.S. citizen spouse. Okay? De todo un poco, I am not actually recommending that to you because I haven't reviewed that fully with you. In order for me to give you that legal advice, I would recommend coming in for a consult first. We can fully understand the situation. But just generally, I have won advanced parole for many clients with DACA and have then thereafter adjusted their status to become green card holders through their marriage after reentry with DACA. Okay? Got it. So I wanted to share that. Eat Zedek 102, I see your follow-up here. It's for deferred action, but not through the military. Okay, this is interesting. Thank you for asking this. You're disabled. You came to the United States at the age of 3. Okay, and so you filed a G325A along with what type of request? Deferred action. So anyway, I don't know what type of deferred action that refers to then, Eat Sadek 102. And so what I would recommend is having a detailed consultation with an attorney and really getting to the bottom of that. All right? Because you can't just apply for deferred action and get it approved. You can't they'll just deny it, right? They'll just deny it. So you want to be cautious about that. All right. So thanks everyone. I think those are all the questions that I've got. I really appreciate everybody for being here. Thank you so much. And my name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. If this was useful, if this was helpful, please take a moment, go to our channel in YouTube, and hit the subscribe button to our channel in YouTube. When you're there, if you also hit the notifications bell, you can receive a notification whenever we upload an additional video with updates and news and things of that nature. And if you are an immigrant and if you are in need of legal help, then hey, feel free to contact our office. We are here to help and we would love to help. All right? Thank you all so much for being here. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. I really appreciate each of you, and we'll see you next time on our next episode of the Empowered Immigrant Live. Thanks a lot, everybody. Make it a great day. Take care. Bye-bye.